On May 20th, 2012, a New York auction room sold a nearly complete Tyrannosaurus Bataar skeleton for $1,052,500. The winning bidder was anonymous, present only by telephone. The hammer fell, cameras flashed, and the sale looked finished. Then federal prosecutors filed a case whose named defendant was not the dealer, not the auction house, not the buyer. It was the dinosaur. If the United States won, the skeleton would leave the sale chain and go back to Mongolia. The case was a civil in rem forfeiture action in the Southern District of New York, captioned, United States vs. 1 Tyrannosaurus Bataar Skeleton. In rem means the property is before the court, not a criminal trial against a fossil. You will hear both sides. Then, before the ruling, you decide. Start in Gainesville, Florida, with Eric Procopi, a commercial paleontologist and fossil dealer. His world was crates, restoration tools, packing foam, invoices, shipping routes, and customs forms. Between 2007 and 2010, he imported Tyrannosaurus Bataar fossil material in 4 shipments that prosecutors later connected to Mongolia. Before the $1 million headline, there was a paper trail. In early 2012, Procopi routed a nearly complete skeleton through the United Kingdom before it entered the United States. On U.S. customs forms, he declared Great Britain as the origin. That single line of paperwork would become one of the case's hardest facts. The skeleton reached Heritage Auctions in New York. Under gallery lights, its mounted frame became a luxury lot. Jaws open, tail balanced, bones posed for drama. Before the sale was completed, the government of Mongolia obtained a restraining order. The sale still proceeded, but any final transfer depended on court approval. Paleontologists entered next. Bolor Minjin publicly identified the specimen as a national loss. Mark Norell publicly flagged it as looted from the Gobi Desert. Then Mongolian President Elbek Dorj personally campaigned for the skeleton's return. What had looked like a niche fossil fight became a state-level demand. Procopi's attorneys, Tampa and McCullough, moved to dismiss the case. Their argument was not simply that their client was a legitimate dealer. Their argument was that the government's theory still had to establish lawful grounds for forfeiture, not just public outrage. Their first argument cut at the foundation. The defense argued the government's ownership theory relied on Mongolia's 1924 Soviet-era constitution, while Mongolia itself, they said, adopted a new constitution in 1992 that recognized private property. On their theory, the government had not shown how the old national ownership rule survived. Their question to the court, stolen under what law? Their second argument was state of mind. The defense said Procopi did not know the skeleton's source country. Their third argument was labor and transformation. By their account, roughly 50% of the organic material had previously been acquired in the United States, and Procopi assembled the mount with his own time, skill, and labor. That defense has force. A fossil mount is not just dirt lifted from a hillside. It can be fragments, preparation, reconstruction, replacement pieces, expert judgment, and thousands of hours of work. If, as the defense claimed, half the material was already here, and if the finished mount reflected substantial assembly work, the court had to ask what exactly was being forfeited: raw heritage, finished labor, or both. The government's answer was narrower and colder. A spotlit sale does not prove lawful title. Restoration could increase value without curing illegal importation. Good craftsmanship could explain price without explaining provenance. And if prosecutors could tie the specimen to protected foreign property, false import documents, and a commercial market would not make it safe. In June 2012, the United States filed the civil forfeiture action. The caption sounded bizarre, but the move was familiar to forfeiture law. Target the object the government says can be taken out of private commerce. The case name made the twist unforgettable. The defendant was not Procopi. It was 1 Tyrannosaurus Bataar Skeleton. On September 24, 2012, prosecutors filed an amended complaint. It included paleontologists' reports stating that the first Bataar skeleton undoubtedly came from Mongolia's Gobi Desert. The word undoubtedly mattered because the government was putting scientific origin evidence directly into the court file. The dispute then split onto a second track. In October 2012, Prokopi was arrested on smuggling and stolen property counts. In December 2012, he pleaded guilty and consented to forfeiture. That changed the posture of the case, but it did not mean every civil defense had been tested on the merits. The fossil case carried the object's name. The criminal case carried the dealer's. The record now held two unfinished stories. The defense had argued uncertain ownership law, lack of knowledge, mixed materials, and skilled labor. The government had expert reports, shipping history, and import declarations that did not match. After the plea and consent, the question was no longer whether every defense theory would survive a trial. It was what judgment the court would formally enter, and those defenses would never be fully tested. The practical stakes were simple. If forfeiture failed, the anonymous buyer's path could reopen. If forfeiture succeeded, the buyer's path ended at the courthouse. No private showroom, no clean million-dollar victory. The mounted skeleton's next move would be decided by federal judgment, not by the highest bid. Before the plea and consent, that was the fight. Did the government's origin evidence and import records establish grounds for forfeiture, or had the defense exposed a real gap in the ownership theory? The court would not test every defense at trial. Decide how you would have read the record before the final order. Comment your ruling before you scroll. Here's what the court actually found. On February 14, 2013, Judge P. Kevin Castell entered judgment of forfeiture for the United States in the Southern District of New York. The judgment formalized what the plea and consent had set in motion. The court order, not the auction, changed the skeleton's legal status. In the stillness of that order, the million-dollar dinosaur changed hands. No roar, just ink. The result was not about spectacle. The sale price made the story famous, but provenance made the legal result possible. The court had an amended federal complaint, scientific reports, the shipping path, import declarations, and Prokopi's consent after his plea. The strange caption did not make the case unserious. It made the object impossible to ignore. In May 2013, the United States returned the skeleton to Mongolia. It was first displayed in a pop-up museum on Bataar Square in Ulaanbaatar. Bones under lights again, people gathered again, cameras again. This time, the setting was not a sales floor. It was a public square in the capital city that had fought for it. The human aftermath did not vanish. For Mongolia, the case became a visible recovery of natural heritage. For Prokopi, it ended in punishment as well as forfeiture. He was later sentenced to 3 months in prison. One skeleton produced 2 concrete endings: museum visitors in Ulaanbaatar and a prison term for the dealer. The court ruled. Did it get it right? Next time, a New York court ruled, officially in writing, that a house was legally haunted. Subscribe for that one.